Hello there, attorney Andrew Bethel, here to talk about another marketing term that's now filtered its way into my clientele that I'm now getting questions asked about. So the latest phrase I'm getting a lot of questions about is a living inheritance. What is it? Why can we do it? And is there a reason why we would want to do that as opposed to doing just a normal distribution out of a trust or through probate? So without further ado, let's jump into what a living inheritance is and how it relates to another topic, ademption. So, a living inheritance. This is something that we've now had quite a few clients begin asking about, and at first I wasn't quite sure what they were asking about when it was first told to me. So, after doing a little bit of searching, I found out that really it's nothing in particular. To be more precise, it's a marketing term. Something that other attorneys started putting out there to say, hey, come to us and let's discuss a living inheritance as a new way in order to pass down your assets to your kids. Now, when we say living inheritance, the idea is I'm giving it to you while I'm still alive. So you're going to get all of your stuff early, and now you don't have to wait until after I pass away. You've already received it. If we're talking about just giving some folks cash or personal property, well, no problem. Go ahead and give all that stuff out if you want. But when it comes to assets like real estate or stocks and bonds, things that appreciate in value, you might want to think twice about just going and handing that out like candy. When you give something to somebody without the expectation of receiving anything in return, that is a gift. And of course, the IRS doesn't want you to just give everything away. They're going to want their little piece of the pie. And that's where something crops up that I've talked about many times before, although not lately, gift taxes. Gift taxes is a tax that the IRS levies on the giver of a gift, not the recipient. If you give somebody something of value, doesn't have to be cash, you can give them a house, a car, or anything in between. If you give something to somebody and it has value, then the IRS is interested in what you gave to them, because the IRS does not want you, essentially on your deathbed, to just give away all your stuff for free and now they can't tax anything after you pass away. So that's where gift taxes come into play. It's a gift that the giver pays when they give something away. Now, they're not going to pay it for every single gift that they make. It's when the gift exceeds a certain value, or really cumulatively, you've exceeded a certain value in gifts to a certain person within 1 year. That is your yearly gift tax exemption amount. Now, this amount was fixed at $15,000 for a while, but it has been increasing by $1,000 every year for the past few years. This year in 2025, it is currently $19,000. That means I can give up to $19,000 of value to one person before ever having to owe a gift tax. Of course, I could give more than that in a year, but if I give it to different people, let's say $10,000 to this person and $10,000 to the next, well, that's not more than $19,000 per person, per recipient, so the IRS doesn't get to tax any of that. But if I took that same $20,000 and instead gave it to one person, then the IRS wants to tax that overage of $19,000. So I gave $20,000 in this example. The first 19 is exempt, tax-free, but anything above that $19,000 is then going to be subject to a 40% gift tax. So I am going to owe the IRS 40% of the next $1,000 beyond that first 19 grand. Now, there are ways to avoid having to pay this, and that's where we tap into our lifetime gift tax amount. Our lifetime gift tax amount, our exclusion, is equal to the federal estate tax exemption amount. Your estate tax is the tax that your estate pays after you pass away. Currently, that's the astronomically high number of $13.99 million per person. Next year, that number is going to be a flat $15 million. However, what that does mean is that's how much money I can have in my estate when I pass away before estate taxes are owed. If I have less than $13.99 million, which statistically that's going to be the case, then no estate tax is going to be owed. But while I'm alive, what if I wanted to tap into that exemption amount early? Well, the way you do that is you give more than the yearly exemption, more than $19,000 in a year to any one particular person. And then for that overage, I just tell the IRS I did it. The way we do that is you're going to typically file Form 709 with the IRS in the year in which you gave the gift on your normal tax return. So essentially what you're doing is telling the IRS that you gave a gift over $19,000 in a year to one person, but that you want to apply that gift towards your lifetime exemption amount. Tap into that estate tax number exemption early and avoid having to pay a gift tax now. Now, bringing it back around to a living inheritance, sure. If mom wants to give her house to her son now while she's still alive, she can do that. But the value of that house, I'm sure, is going to be way more than $19,000. And so in order to avoid any sort of IRS coming after her and trying to levy a gift tax on that overage, mom would just have to tell the IRS that she made that gift, but apply that towards her lifetime exemption. The thing is, in the instances where I was reading about living inheritances, nobody was really mentioning that aspect. I'm sure it's a way to get people to call the office and say, hey, I'm interested in setting up a living inheritance. Can you tell me more about it? And then they rope them into doing amendments to their trust and walking them through the steps. And oh yeah, by the way, you need to go to my accountant and they'll get the appropriate tax form filed so you don't have to pay a gift tax. But at the end of the day, a living inheritance just means giving a gift to somebody. Now, that is kind of related though to another topic that has arisen in the office, and that is ademption, or also known as an advancement on somebody's inheritance. The way it cropped up in our office recently is a mom has passed away and she's got a couple kids. For one of her daughters, she left about $20,000 or so to, and the daughter who's in charge of administering the trust is turning around and saying, well, mom gave you about $11,000 or so over the past 10 years while she was alive, so I'm going to subtract that $11,000 from your $20,000 inheritance, and therefore you're only going to get $9,000 out of this all. Sign here on the bottom line and let's close this out. Well, doesn't really work like that, but let's kind of back up. Let's lay the legal groundwork first. The phrase is ademption by satisfaction. It's also known as an advancement on one's inheritance. It occurs when a person makes a during life gift to a beneficiary that is intended to count as a reduction or satisfaction of a gift the beneficiary would receive under the will or trust. So, in essence, I'm going to give you $10,000 now with the understanding that when you get your inheritance later, you're going to get $10,000 less at that point in time because I'm giving it to you now. The question is, how do we even set this up though? The intent is key. For a gift to operate as satisfaction, the giver's intent to satisfy the future gift needs to be clear. And this has to be through documentation. The intent must be shown by the will or the trust itself. There should be a contemporaneous writing by the person creating the document, the testator or settlor. There should also be a written acknowledgement by the beneficiary that they understand what's going on. And lastly, if there's any question on the matter, the probate court is going to be the one who's going to turn around and say, yes, this is an ademption satisfaction, or really an advancement on somebody's inheritance, or for all we know, that was just a gift that mom wanted to give their kid while she was still alive, give them their full inheritance due under the trust. Now, not to give away too many details, but in our case, there's no writing done at the same time that mom gave any of those gifts to her daughter that mom intended for those gifts to be an advancement on that daughter's inheritance. Plus, there's nothing by that daughter acknowledging that those were advancements on her inheritance. So at the end of the day, in this case, that daughter who was running the show with the trust was just sort of making some stuff up. However, this is something that some folks do like to plan around. So oftentimes when we do want to work this into an estate plan, we'll have a ledger attached to the back of the trust to where we're going to indicate whether or not there's been any loans or advancements to any future beneficiaries so that that can be accounted for properly later when we're doing the trust administration, after the testator, the person who created the trust, after they pass away. In essence, Those are living inheritances, things that we've already been doing for a long time now, just with a different name. Whether it's living inheritance, advancement, ademption by satisfaction, just know that at the end of the day, if you are creating your will or trust and you've already given somebody some sort of gift, one, we want to make sure the taxes are all squared away, and two, you can take that gift into account when doing the distributions later on. However, I hope you've realized that at the end of the day, with all these things, documentation is key. We need to know that that was your intent. And the only way we're going to know for sure is if you put it down in writing. And with that, that requires going to a knowledgeable attorney who's going to be able to walk you through that process, get everything in writing, squared away for you, and at the end of the day, be the witness on your behalf that yes, this was your intent to create either a gift now or an advancement on somebody's inheritance. So what do you think when it comes to advancements on somebody's inheritance or a living inheritance? Have you given any gifts to folks that you would hope gets acknowledged when it comes time to distribute your trust at the end of the day? Do you have it in writing? If not, you're definitely going to need to talk to somebody. But with that, thank you very much for watching. I really appreciate it. Let me know if you have any questions or any comments on today's video or a topic you want me to cover in more depth. Let me know down in the comments below. I'm attorney Andrew Bethel, and I'll see you at our next meeting.